permits the arbitrator to award attorney's fees to the prevailing party. On December 22nd, 2022, Mr. Logsdon resigned from Comerica. He then proceeded to violate his non-compete. He also violated a non-solicitation agreement. March 10th, 2023, Mr. Logsdon filed a wage claim with the Texas Workforce Commission. He claimed that Comerica owed him money. On September 27th, 2023, the Texas Workforce Commission dismissed the claim because of the arbitration agreement. You see to the right is Exhibit 3 or Exhibit 34. The claimant signed an arbitration agreement on November 1, 2018. It has the language of the part of the arbitration agreement. It says that he read, understood, and signed the arbitration agreement when he signed it. And it goes on to say that an agreement provides arbitration shall be the sole method of resolving the disputes. On March 1st, Comerica initiated an arbitration with the AAA. The November 1st, 2018 arbitration agreement was attached as Exhibit 2 to the demand. On March 7th, 2024, AAA sent a list of arbitrators. Shortly thereafter, on April 15th, 2024, pursuant to the agreement and the AAA rules, Comerica sent its rank and strike list. You can see the email from Mr. Jones on Exhibit 7, April 15th, to Haley Casdorp at AAA. It clearly strikes Hartsfield. On 4/15/2024, same day, Mr. Logsdon filed a counterclaim in the arbitration. He is seeking affirmative relief in monetary damages. He does not object to jurisdiction. He does not object to arbitrability of the issue. On 4/18/2024, the AAA appointed Mr. Hartsfield, despite him being stricken by Comerica. They then realized their mistake and they send out an email saying claimant strikes were mistakenly entered as their rankings, not by Comerica as represented by Mr. Logsdon, but by AAA. And therefore, AAA realized that Mr. Hartsfield had been improperly appointed.
Objection. Objection. He's mischaracterizing what I stated. I even came back and clarified that.
Okay.
What I said.
One at a time. One at a time. So you can speak at the end. So go ahead.
So Mr. Hartsfield was the AAA improperly or mistakenly swapped the ranks and the strikes and appointed somebody who had been stricken. They said that would have been proper if it would have been violation of the party's agreement and the rules. On 4/26/24, Judge Ashby circulates her initial disclosure. She makes broad disclosures about the fact that she had been a judge since 1987 in various capacities. She knows lots of lawyers. Many have appeared in front of her, and it does not impact her ability to be impartial or to fairly hear the dispute. Notably, in the disclosure, it says that, or let me say this, on 4/29, she's appointed. In the appointment, the AAA says, if you have an objection to Judge Ashby, make it by May 6, 2024. No objection was made to the process. No claim was made that anything AAA did violated any rule or any procedure by the AAA. On June 20th, 2024, Judge Ashby enters a scheduling order. The scheduling order provides the AAA employment rules and the Federal Arbitration Act govern this dispute. It contains the same electronic signature that will ultimately be of issue in the final award. On May 20th, 2024, Judge Ashby, through the AAA, sends out a disclosure about a relationship that Mr. Wishu mentioned with Mark Shank. Judge Ashby discloses her relationship with Mark Shank. She says this will not affect her ability to be fair and impartial in this matter. It is sent to David Fielding. You can see that at the top. That is, Mr. Logsdon's attorney. It's sent on June 20th, 2024. It says that if there's any objection to the appointment of Judge Ashby, it needs to be made by June 25th, 2024. No objection is made. It also states, pursuant to the AAA rules, that if an objection is made, the AAA will make a determination regarding the arbitrator's continued service, which shall be conclusive. And that'll become important later. On July 9th, 2024, Mr. Logsdon moves to dismiss Comerica's claims. He requested the arbitrator to make a substantive ruling on the legal validity of the non-compete and non-solicitation provisions. On 7/29/24, the arbitrator denied the motion. The order denying the motion to dismiss contains the same electronic signature that is on the final award. On October 25th, 2024, Coverica moves to compel discovery. It seeks 2 letters that Mr. Logsdon received from the IRS. Mr. Logsdon responds on December 19th and claims IRS code 6103 prohibits the court from compelling disclosure of the letters that Mr. Logsdon received from the IRS. On January 24th, 2025, the arbitrator overrules Mr. Logsdon's objections for obvious reasons. There are exceptions to 6103. 6103 protects disclosure of the taxpayer's information. The information at issue in the IRS letters was Coverica's taxpayer information. In addition, disclosure permitted in judicial proceedings where the taxpayer, i.e. Coverica, is a party. Again, this Exhibit 18 contains the same electronic signature as you'll find on the final award. On January 24th, 2025, Judge Ashby issued a supplemental disclosure disclosing an innocuous relationship with a vendor who happens to employ David Fielding's son. Again, she says this will not affect anything. We impartial decision. On February 11th, 2025, Mr. Logsdon again moves to dismiss. This is not an objection to the arbitrator's jurisdiction. It's not an objection to her authority. It's not an objection to the arbitration. Instead, he is asking the arbitrator to determine which arbitration agreement governs this case. The November 1, 2018 agreement or a subsequent agreement that was never signed that was put out in 2022. Mr. Logsdon is deposed shortly thereafter. On February 25th, Mr. Logsdon requests for continuance. On March 4th, 2025, the judge amends the scheduling order. In conjunction with the motion for continuance, the judge gave additional time for discovery, delayed the final hearing by 2 days. Instead of starting on March 10th, it would start on March 12th. There was no further objection, no request for continuance after that. On March 4th, the arbitrator also denied Logsdon's motion to dismiss based upon the arbitration agreement. She says the Logsdon signed the binding arbitration agreement on November 1, 2018. The other one he did not sign. Thus, the arbitration agreement, being defined as the November 1, 2018 agreement, is the only signed agreement to arbitrate between the parties. The arbitrator went on to say that he waived any objections because under the AAA rules, they had to be made by April 15th, 2024, when he filed his answer. In addition, the arbitrator found that she had jurisdiction. March 11th, 2025, Logsdon files his pre-hearing brief. He seeks damages and attorney's fees for breach of contract and fraud. He requests the arbitrator find the non-compete is not unenforceable, a liquidated damage clause is unenforceable, and that he is immune from Coverica's claims because he is a whistleblower. Notably, he did not object to arbitration. He did not claim they did not have the evidence they needed to go forward with the arbitration hearing. On that same day, Logsdon filed his amended response and counterclaim, again requesting the arbitrator adjudicate his claim, award him contract and court damages, and award him fees. On March 12, 2025, Judge Ashby learns this is the day the arbitration is to begin. Judge Ashby learns that Mr. George Flint has recently been hired as Coverica's new general counsel. She found out that morning. She immediately at 9:21 a.m., you can see this email, Exhibit 26, sent a disclosure making a very tenuous disclosure of a very tenuous relationship with Mr. Flint. She misspells it and says that George Floyd is in the arbitration room and is new general counsel for Coverica. I tried a jury trial with him when I was in the district attorney's office, which had to be before 1987. I believe I worked on some additional matters when I was the associate judge in the juvenile department, and maybe when I was in the county court of law in the 130 plea. It would not cause me to be biased or prejudiced in any way. So to be clear, upon learning that Mr. Flint was the new general counsel for Coverica, Judge Ashby immediately disclosed her prior professional relationship with Mr. Flint. On that same day, Logsdon objected to Judge Ashby based upon the information disclosed. They said that they knew last week during his deposition, the Logsdon's deposition, that Mr. Flint and Judge Ashby had a case with each other, but they just learned that there was a more extensive set of dealings with each other. Coverica addressed Mr. Logsdon's objections. You can see that it was also in Exhibit 26 of the email chain. It said he recently hired, he attended Mr. Logsdon's deposition and immediately disclosed to Arbitrator Ashby. As soon as Arbitrator Ashby became aware of Mr. Flint's involvement, he made the disclosure this morning. Mr. Flint's professional experience with Arbitrator Ashby occurred.
Wait, so let me make sure I understand what you're saying, Mr. Lang.
Yes.
So it said, are you saying that there was a more extensive set of dealings other than these interactions many, many years ago, or is that the other side saying that?
That's the other side saying that, but the only evidence of any interaction is Judge Ashby's email right here, which talks about a jury trial when she was in the DA's office, which had to be 1986, 87, before she took the bench as an associate judge. And then while she was in the juvenile, she believed she worked on some additional matters. And then maybe when she was at the county court law or at the 134th. There was no other extensive relationship, and there's no evidence of any extensive relationship. Mr. Jones' email went unrebutted. There is no evidence that outside of the professional interaction, which we will show you under the standard is insufficient to create any issue, that there's no other evidence of any relationship between Mr. Flint and Judge Ashby. And so, again, the relationship was over 30 years ago, if there was one, trying a case with somebody as co-counsel. Again, it was over 30 years ago.
I want to object. I'll bring it up at the end.
Okay. So pursuant to the AAA rules, the issue was submitted to the AAA, who said, after reviewing the party's position, the AAA has decided to reaffirm Judge Ashby's appointment as the arbitrator in this case. And that's important because in the AAA rules, which are part of the arbitration agreement, the parties agreed that if there is a conflict issue, it is submitted to the AAA, who has the authority to make the final determination, and that is conclusive. So the final hearing took place between March 12, 2025 and March 14, 2025. On April 14, 2025, Mr. Logsdon submits a proposed award with findings of fact seeking in excess of $272,000. Coverica, pursuant to the arbitrator scheduling order, also submits a proposed award with findings of fact. On April 22nd, Mr. Logsdon's attorney also submits an affidavit seeking attorney's fees. On April 25th, Plaintiff's Exhibit 31, there's an email from the AAA to all the parties attaching the final award. It was sent at the direction of the arbitrator. It's executed by the arbitrator. There's no allegation that the award Coverica seeks to have confirmed is not attached to this email. The findings of fact disposed of all claims and found against Mr. Logsdon. On May 17th, almost a month later, Mr. Logsdon sends an email to the AAA objecting to the procedural handling of the arbitration selection because of the removal of Mr. Hartsfield. It's the first time any objection is made, and it's the only time it's made in writing, and it's almost a month after the arbitration award ended. Notably, in that letter, Mr. Logsdon says and admits that the arbitration in this matter was conducted pursuant to a written arbitration agreement between the parties. That agreement governs both the scope of the arbitrator's authority and the procedures by which the arbitration is going to be conducted. On May 20th, Comerica moved to file the petition to confirm. On May 27th, the Logsdon filed a separate lawsuit in the 160th District Court against the officers of Comerica, alleging the same claims based upon the same facts. A day later, he filed a suit in the Northern District of Texas, alleging RICO against the officers of Comerica, based upon the same facts at issue in the arbitration. On June 12th, he filed an answer and objection to Comerica's petition to confirm. And on June 25th, 2025, he filed his first amended motion to vacate. I think the big picture summary of the facts is.
So what is the current status of the case in the 160th in the Northern District?
I believe he just non-suited that within the last day or two. And then the Northern District of Texas, the 160th. In the Northern District of Texas, we filed a motion to dismiss under 12B and Rule 9, and he failed to respond by the deadline to file an answer, and he non-suited that the day after the deadline passed. So that was last week. I know Thursday he non-suited it.
Wait, so he non-suited both those other cases?
Yes.
Okay.
So the big picture from these facts is we're going to hear all these complaints about Judge Ashby, about the evidence, about the procedure, but the fact is about the jurisdiction, about the validity of the arbitration agreement. Mr. Logsdon filed a claim in the arbitration. He pursued a claim in the arbitration. He sought damages and fees in the arbitration. He requested the arbitrator on several occasions to determine which arbitration agreement controlled. He filed a pre-hearing brief. He filed a proposed award awarding him fees and damages, and he lost. If he had won, nothing about the agreement would be an issue. Nothing about the award and the signature on the award would be an issue. Nothing about jurisdiction would be an issue, and nothing about the judge's signature would be an issue. This is sour grapes, plain and simple. And now we're going to get into, there are two issues that probably need to be teed up or discussed before we get to the end is does the FAA or the TAA apply? So the Federal Arbitration Act applies if the dispute concerns a contract evidencing a transaction involving interstate commerce, and commerce is commerce among the several states. On the face of the employment agreement, Mr. Logsdon was hired and employed by Comerica to retain, service, solicit, and produce insurance business in various states. Comerica operates across the continental United States and Hawaii. There is no doubt, and there's not even an argument that the FAA does not apply. The Texas Workforce Commission found that the claimant in this case was involved in interstate commerce, and so this agreement is covered by the FAA. Mr. Logsdon's attorney agreed that the FAA applied when he agreed to the proposed scheduling order that says that it is governed by the AAA rules and the FAA. This is Mr. Fielding agreeing to the rules, it looks fine to me. The arbitrator's scheduling order says that the entire proceeding is governed by the FAA and the AAA. The legal standard for confirmation and grounds for vacate. This is important because review is, as the Fifth Circuit said and the Northern District have said, is exceedingly deferential. Any doubts are resolved in favor of upholding the award. The court must confirm an award unless it is vacated, modified, or corrected. The court has no authority to review an arbitrator's decision on the merits, do not vacate based upon errors in interpretation or application of the law, or mistakes in findings of fact. There are 4 exclusive grounds to vacate under the FAA. The award was procured by corruption, fraud, or undue means. There was evident partiality. The arbitrator was guilty of misconduct by not granting continuance or refusing to hear evidence, or the arbitrator exceeded her powers. That's it. Those are the sole grounds. Manifest disregard of the law is not grounds to vacate because it's not within the statutory 4 grounds, and public policy is not grounds to vacate because it's not statutorily within 4 grounds. Here, we have a valid final award. It's undisputed that AAA sent the award that Comerica seeks to confirm, and there's no basis to vacate. If we need to get into kind of where we left off last time, which is Mr. Logsdon argued that because he claims that a 2022 arbitration agreement superseded the 2018 arbitration agreement, this court needs to determine which one controls. We can get into that now. If he wants to make that argument, we can respond. But I'll tell you right now, under the U.S. Supreme Court, the Fifth Circuit, the Texas Supreme Court, and the Fifth District Dallas Court of Appeals, all gateway and threshold issues were delegated to the arbitrator, including the validity, enforceability, and the existence of the arbitration agreement.
Okay, anything else?
No, if Mr. Logsdon wants to go into that argument, I'm prepared to respond.
Okay. Response? Go ahead and stop sharing.
Yeah, working on it.
So I have several items to actually respond to, but the main thing is I want to make sure I clear up my objections. So the objections that I had put out there was about the statement about Mark Shank and the record of not receiving it. I had clarified that in my briefing that it was relating to AAA is advertises that their web file system, and that their protocol according to the rules is that when something's disclosed, it's sent out to the parties and it's housed in this web file system. Those items that were identified were not housed in the system, as I downloaded all that entire record and uploaded it to the court. It's not in there. The second thing is the part of the discrepancy with
Mr. Lang, what's your response to that?
It was sent, it's irrelevant. It was sent to the parties. His attorney received it. His attorney of record was on the email, and there's no claim from his attorney. There's no evidence in the record or affidavit from his attorney. And I'm not shocked why his attorney wouldn't make that representation that he didn't receive it.
I didn't say that. He did.
Exactly. It's a red herring issue. That's my response.
Okay. The next part is in relation to the part of my objection is about George Flint. George Flint never made an appearance. He is a part-time general counsel, and he also has his own shingle as an arbitrator mediator. He should have made an appearance according to AAA rules that would have notified the arbitrator prior to the day of hearing, 9 minutes before the hearing starts, that he is representing Coverica. The other side didn't follow the rules of disclosure themselves. So that's my other objection before I answer the rest of it.
Okay.
You want a response?
No, you may proceed. Anything else?
May I share my screen?
Yeah.
Okay. Okay. So the grounds for vacator, as Mr. Lang put into context, is exactly what I have up here, or there's no agreement to arbitrate. The case law that I had found that was most applicable to my case that I have cited before was Janvey versus Aguilar, where the parties are bound by a given arbitration clause, raises a question of arbitrability for the court to decide. And secondly, arbitration agreements may be rejected when they're instruments of a criminal enterprise. As these arbitration agreements were, the Federal Arbitration Act evinces Congress's desire to enforce arbitration agreements, an expression warmly embraced by the judiciary, but there's limits. There is the fundamental basis of this entire lawsuit and arbitration is surrounding a whistleblower actions that came into light. Just the very background of it is it surrounds this entity called Coverica Cares Incorporated, which was advertised as Coverica Cares Fund. Coverica Cares Fund was part of this arbitration process, but in the reality, it came to light that Coverica Cares Inc. never existed while I was employed, and the Coverica Cares Fund never existed until I brought it up to light and brought up issues and started reporting it to the IRS, the TDI, the OIG, the Small Business Association, for actual legitimacy. In fact, there's even evidence from the so-called beneficiary of the nonprofit that said we've never received any type of donation from this fund or from Mark in 2020 and 2022, which was the whole basis of this litigation. The arbitration was used to get information about what was presented on the non-Coverica Inc. entities. It was a fishing expedition. Coverica Inc. was not the entity that was reported to these different entities. It was Coverica Cares Inc. It was Michael Sterlacy. It was the officers of the entities that were involved, and the other numerous companies that were involved in this funneling of money. Caris Enterprises, Coverica Agency Alliance, all non-entities of Coverica Inc. They weren't related. They're not owned by each other. Coverica Inc. was not tied into it. However, it was used in order to fundamentally do a fishing expedition in this process. Further, I have the arbitrator exceeding their powers. She ruled on the business disparagement claim under Coverica's Inc. for Coverica, even though it was a separate entity. You can't, she had no authority or powers in order to incorporate Coverica Cares Inc. and the claim that was filed against that on the regulatory authorities to then use it against me in an arbitration against the prior employer under business disparagement. But it happened and it was done. And I have further explanation of that further down. Utilization of the 2018 version instead of 2022. The precedent for it's clear. There's a carve out in the 2022 language. There's also a clause that an inclusion clause, a merger clause that brings forth the employment agreement that prior wasn't incorporated. See on here on the 2018 version, it's very bland. It does not ever mention Coverica. It doesn't mention anything outside of employer, employee, and it calls it agency. But there's no reference to Coverica anywhere on here. The 2022 version is peppered with areas of where it specifically states that any type of arbitration related or any type of claim related that comes into play is excluded from the arbitration proceedings. The part that brings this part forward is the fact that one, it was incorporated into the handbook just like the prior one. And second, it has a mergers clause where it actually identifies the producer's employment agreement, whereas the prior one did not. All of this was shown to the arbitrator Ashby, and it is exceeding her powers when she's shown something in black and white and ignores the fact that it would have restricted the basis of the claim. And the claims that would have been excluded would have been everything except the business disparagement and the business disparagement claim that was levied by Coverica. All the rest of it was tied to causes that are directly inside the employment agreement. The evident partiality, there was a non-disclosure of counsel of the arbitrator relating to Shields Legal Group. I not just myself, but the statutes and the Fifth Circuit have agreed that there has to be disclosure of anything that could be or show impartiality. Even though the FAA is in charge of this, it does still leeway to where the Texas Civil Practice Remedies Code says that you cannot waive the disclosure of a person serving if they are the sole arbitrator. They have to disclose. This isn't a matter of an option. The of counsel role of Shields Legal Group is important due to one, the size of Shields Legal Group, the proximity to the prior employer, the fact that they are also involved with community foundations of Texas, which is a central focal point of the entire arbitration agreement, or the entire case, is whether or not my prior employer truly had a relationship that allowed them to be a charity. And further, the uh, there's no way to know if there was disclosure, if there was a conflict, because there was no conflict check ran. With the amount of litigation and how litigious my prior employer is and the size of who they are, it is very likely that they have come into or been used within the last 10 years. Further, it's not up to me or the other counsel to say that they don't need to disclose. It's for us to be able to understand that and take that and run with it. The further is the George Flint relationship. As I mentioned earlier, there was the objection because of the not notifying his appearance, but further, there is a recording that I've made of the entire trial because of the fact that I needed to make sure that we have everything in place and in force, and the trial transcript of
Your
what
Honor,
was
I'm
recorded.
going to have to object here, and I apologize, Mr. Logsdon. We have objections to Mr. Logsdon's attempt to create a transcript of the arbitration proceedings. As Your Honor is aware, arbitration proceedings are confidential. The AAA rules and the arbitrator scheduling order put out a procedure to have them recorded. You give notice, you get a licensed stenographer, and then you can have them transcribed. The scheduling order by the judge says no other forms of recording are permitted. Nevertheless, Mr. Logsdon secretly recorded the entire proceeding and then tried to have them transcribed, not by an official court reporter. They're a mess, through some AI or some app that try to transcribe it. They're incoherent, but the more important thing is it is a direct violation of the arbitrator's order to secretly record the arbitration proceeding. It's one of the more unethical things I've seen in my career.
With the level of amount of information that's completely untrue that's in the record that's right now, the recording is the only one that has an accurate representation. The written transcription that I'm going to get through further down here, I've highlighted all of it, is completely wrong. It's not a matter of mishearing it or misunderstanding it. It is completely
Mr.
wrong.
Locke, just so you know, you've been going quite some time. I'm going to give you another 5 minutes, and then we're going to go ahead and shut this
Okay.
down for now. So go ahead and get to your main points.
Okay. During the trial, the arbitrator felt the need in order to stop.
And how
Stop
do you
the,
go ahead and keep time for me and go ahead and give them a countdown like 3 minutes out loud, 2 minutes and 1 minute.
She stopped the questioning of of Rhonda Cox to ask if she needed to disclose her Sheaf and Stone conflict. George Flint represented me, Mark Logsdon, while he worked at Sheaf and Stone, and in 2018, prior to me coming to Coverica Inc. Not disclosing is a direct issue. Arbitrator misconduct. I had a third child in December 2nd, 2024. My second child had to go in on February 2025 to have surgery. And I asked for an extension till October because I had children, obviously issues, but also we were missing discovery and we needed extra depositions. I did record that. That was not part of the trial. And the arbitrator refused to move anything. We asked 3 or 4 different times and she refused to move it, move the trial date, move anything. We had to perform under duress. 95% of the award matches the plaintiff's proposed award, and it just has complete inaccuracies, things that are not supported in writing and anything in the evidence, nothing in recording. Thank God had that. And there's a question on the award chain of custody. As Mr. Lang showed, there was an email that came from the AAA that had the award, but the award itself, the PDF, was created by plaintiff's counsel. It has author, plaintiff's counsel, clear as day when you go into the metadata, when you go into the properties of the PDF. The chain of custody should have gone arbitrator, AAA, plaintiff, defendant. That's not what happened. What happened is plaintiff's attorney, God knows who it went to, AAA plaintiff defendant. I've highlighted the portions and shown on here. There's no fact to back up what is written down in this document. That's the award and is also the plaintiff's draft of an award. There's no explanation of the dollars that they're saying and how the breakdown is. The claim of a draw is very clear as day in a secondary producer's contract, but in mine, it's used in here, it's referenced in here, but it doesn't exist. There's no record or trial of the Texas Business Code 15.50. Plaintiff's attorney represented that they were not seeking to enforce the non-compete provisions, but clear as day, we've got non-compete provisions in here that are being used in the award construction. There is no territory restriction that's on here. There is no time constriction. This is all misrepresented. There's the penalty clause.
What
And
did you say, Hadia?
I'm sorry.
What'd you say?
We're at 2 minutes.
2 minutes.
There's Coverica Cares Inc. is being used in the Coverica's claim for business disparagement. This entire section is derived based on Coverica Cares, the reports I made on Coverica Cares. But Coverica is claiming the business disparagement, and it is awarded under this arbitration improperly. Yes, Coverica Cares was not a party to this proceeding. There's no proof or evidence of malice that was in here. But yet again, what was reported was under Coverica Cares and the owners of that and the operators of that there was somehow malice that impacted the Coverica arbitration award that yielded the reason to be fair. It's the arbitrator distributing her own brand of justice. It's improper. There's no evidence to support any type of testimony that they were damaged by the claims against Coverica Cares Inc. and the fraudulent charity and how that organization was, or the circular funds, or participating in the IRS hearings with the current tax court cases. None of this stuff was allowed to be involved in here, but yet that entire amount was misconstrued and reapplied to fit Coverica. Coverica was not in any of the stuff that was reported to the IRS, the Texas Department of Insurance, any of those things. And the last part is completely manufactured. There's no part in the employment agreement that creates an obligation, and there's no part
Give him
that
30
says.
more seconds so he can finish.
I'm sorry.
You have 30 seconds.
There's nowhere in the employment agreement that states that it does not convey a contractual right or creates no obligations to employees, that I'm not entitled to recover breach of contract. Nowhere in that contract does it say that, and nowhere in any part of the testimony. In fact, there was unrefuted testimony regards to that Arthur White, that I allegedly bragged to Arthur White and planned to sue the company for millions. Doesn't exist. But all of these things, when you apply it in there, it's the bulk of the award. It does not match the actual testimony and actual facts and information. All of it goes into it is an injustice to me. It's not fair to either side.
Okay. All right, Mr. Lang, you have 1 minute to respond.
Everything he just said goes to why he just thinks the court should have ruled, the arbitrator should have ruled in his favor. Everything he just said was addressed at the hearing and rejected by the arbitrator. The final award elected remedies under breach of contract, which are proved up under a formula in the employment agreement. There's nothing that's been said here. She had authority. All issues were delegated to her. There's no other signed arbitration agreement. This is an absolute attempt just to try to relitigate this as if this is a court of appeals. Whether there's sufficiency of the evidence or anything else, none of that matters. as we sit here today, you take the award as it is in front of you and assume everything in it is correct. And that is the law under the Fifth Circuit. And just to be clear, GMB versus Aguilar does not cite the AAA rules. We can get into that if we need to, but if the AAA rules are listed in the arbitration agreement, then the AAA has a sole authority to determine the existence, the validity, the enforceability, the arbitrability, the scope, and their own jurisdiction. In denying the motion to continue, there's only one email, and it's in there on the motion to continue on sole basis with discovery. There was no other grounds listed, and the arbitrator heard the issues. The parties modified the scheduling order and set the hearing without objection.
Okay, so what was set today, I just want to make clear, there was a motion to vacate and a motion to confirm the arbitration award. Those were both set for today, correct?
Yes.
And then, Mr. Lang, have you submitted an order on this?
Yes, we have, I believe so. If you needed us to send it again, we'll send it.
I don't see it in here. When did you send it?
It should have been, I believe it was filed in the original.
I see it. Was it on 7/7?
I thought it was with the. Hold on, I'm trying to. 7/7? Yes.
Okay. And does that cover both issues?
Allie, I'm sorry, I got somebody looking it up. It should. So I guess there are three awards, and we can put them into one. There's the 7/7 final judgment. There is a separate motion denying his, and a separate one granting the order to confirm. So I guess it was the order to confirm with the final judgment behind it, and then a motion or an order denying Mr. Logston's motion to vacate. And we can put them all into one and make it simple.
Yeah, why don't you put together one order? I'm going to go ahead and grant the motion to confirm, grant final judgment, deny the motion to vacate. Put that into one order, indicate the dates that I know this was over a couple of days that we've had these hearings, what dates the hearings were, whether or not I think they were both on Zoom, that they were on the record and with all parties present. Mr. Alexson, I wish you the very best of luck, and we are done for today. You guys have a great rest of your day. Get me that order by tomorrow.
We'll get it to you. Thank you, Judge.
Thanks, Your Honor.
All right, who's working on that memo?
I
Okay.
am, Judge.
So keep working on it. I'd love to, if you think I may be wrong. I don't think I am. The law
It
is.
was actually, that's exactly what I had, so.
Okay. I mean, the law is just so strongly in favor of arbitration in this. It's so hard to get, I mean, even the best lawyer is not going to get past that. So,
Yeah, that's kind of what I was getting at with like the FAA and the requirements and everything, so it's exactly what I had.
it's harder to overturn a arbitration award than it is a trial judge, that's for sure. But it is what it is. Though they do have a lot of strange disclosure requirements, the fact that she has to disclose every one of those little interactions to me is just bizarre. But I kind of think that's required. Anyway, do you guys have any questions about that or anything else we did this afternoon?
Judge, I just had a question about the memos. I think some of us got them a little bit later. Is the 30th the due date for, or sorry, this Friday the due date for all?
Yeah, let's make it the due date for everyone just so that we can make it easier on Abby so that she can get everything all at once. So let's try to get those into her by noon on Friday. And then she'll send them on to Alexa and to me. So yeah, if y'all don't mind.
Is there any chance that we'd be able to have that weekend or no?
Abby, are you going to be here next Monday?
I wasn't planning on coming in, but I can.
Yeah, that's fine then. If
Yeah.
you guys, if it works for Abby, but everything, Abby's going to put all this together and get that to me. So, all right. Anything else today, guys?
I
Thank you,
have
Judge.
one thing, Judge.
What's that?
For the record, I need to get the name of our timekeeper.
Ah,
That would be me, Hadia Siddiqui.
Okay, let me write that down.
you're going to be part of the court transcript. Congratulations.
Okay, that's all I needed.
So just so it's clear to everyone, we'll be in it tomorrow at 8:45, except for the high school students and Tammy, if you guys can get in at 8:30. Amir, are you coming in tomorrow? Is this your last day?
Yes, Judge, I'm coming in tomorrow. My last day is Friday, this Friday.
Is anyone's last day today? I thought someone's last day was today. No?
It's my last day.
All right, everyone say goodbye to Sarah.
Okay.
Bye, Sarah.
Good luck
Bye,
with
Sarah.
everything.
All your help. I learned a lot.
Good. Corey, are you with us the rest of the week? Corey, are you with us the rest of the week?
Oh yeah. I'm good. I leave Friday. Sorry.
Jonathan, are you with us the rest of the week too?
Yeah, I also leave Friday.
Okay. All right, guys, it's going quickly. We will see you guys in the morning, okay? Bye-bye.
Judge.
Bye.